Good afternoon, everybody. Welcome to the 37th edition of the Miller-Johnson Benefits Lunch Break webinar series. And I'm just joking about 37th edition. We are not counting. My name is Brett Swearingen, and I am one of the benefits attorneys at Miller-Johnson. I practice in our Grand Rapids office. And today I am delighted to talk to you about the topic of missing participants. The title is Lost and Found, Your Duty to Missing Participants. Here's what we're going to talk about today. This is one of those rare topics in benefits law where we have a pretty good idea of what the Department of Labor thinks. They released a set of guidance documents just over 2 years ago, which pretty much lays out their thoughts. So we're going to be running through that guidance from DOL. In particular, the most important document they've released is a document on best practices for plan fiduciaries to follow. And there's two kind of categories there. One, we're trying to make sure we don't lose track of our participants. And if we do lose track, how we can find them and make sure they're reunited with their retirement savings. A little bit about what is in the future on the missing participants topic. And then finally, as always, what should you be doing to make sure you're complying with your fiduciary duties, and especially in the event that there is an audit by the Department of Labor. So background here, I like this topic because this kind of gets the core of why ERISA was written. ERISA, if you don't know, is the federal law that regulates employee benefit plans. It stands for the Employee Retirement Income Security Act, passed in 1974. But ERISA is, the whole reason ERISA became law was the government decided, Congress decided, we need to make sure that if people are promised retirement benefits, they get those benefits. And the issue of missing participants just kind of crystallizes that problem more than any single issue, because you have people here that have done the work, they put in the time, they're owed money under whatever benefit they were eligible for, multiple benefits, and yet whether it's due their own negligence or negligence of plans or just simple mistakes, they are at the end of their careers and not able to access that savings. So to me, it's just a very crystallized example of the reason the law exists in the first place. So what do we mean by missing participants? It's very intuitive, but we're talking about people who have been participants or are participants in retirement plans. Here, we're mostly talking about either the classic 401k vehicles or a defined benefit pension plan, or their beneficiaries in the event that a participant is deceased and the money would now be obligated to one of their beneficiaries. They're either missing, as in the plan cannot locate them, or otherwise just unresponsive to communications that have been sent by the plan, which at the end of the day means that they've earned benefits, they're eligible to receive those benefits, but they're not getting those benefits at the present time. There's kind of three ways that this problem can arise. The three words I want to emphasize are record keeping, communications, and search. The first part of the problem can simply be a breakdown of some fashion in a plan's of record keeping. They've lost track of participants who've moved. A common thing that you see with companies that have gone through mergers or acquisitions, that the participants' information didn't transfer completely from, say, the seller to the buyer, but some kind of breakdown in just the records that a plan is keeping in terms of its participants. A second issue is in communications, how a plan communicates with the people that are in it. And I think the Department of Labor has some good tips for how that can be improved. And maybe some of these things are things that you guys are already doing. And then when you find that somebody is not responsive, you don't know where they are, how do you go try to find those participants and reconnect them with their savings? This last bullet, I think this is just so easy to empathize with, because we can imagine how this would hurt people who, could in some cases have lots of money that they're entitled to, like substantial monthly benefits via annuities or a pension that they're just not receiving. So their injuries are kind of obvious from an ERISA perspective. I meant to mention this earlier. We're really talking about the core duties of loyalty and prudence. ERISA says that plans must be loyal only to the people in the plan. They're not loyal. Your duty is not, as a fiduciary, your duty is not to the company you work for. Your duty is to the people in the plan. And what is a more obvious breach of that duty is if somebody cannot access money they've earned under that plan. The other core duty here is the duty of prudence. And that just means that you are doing what a professional in your situation would be doing to exercise what you're supposed to be doing under the plan. So like for the search function, are you doing your due diligence to try to find these people once it's become obvious that they're non-responsive? Now, the Department of Labor has for a long time, no surprise, taken the position that just because a plan participant may be missing or non-responsive, ERISA's duty of loyalty still applies to that person. And that's why there's issues in DOL audits on this topic. It is a significant issue during audits. It's very standard when the Department of Labor is auditing a plan that they're looking to see what are their policies and procedures for missing participants. Are they following those policies and procedures? Are they doing what they should be doing to try to track people down on the back end, on the front end? Are they making sure their records are complete? Are their communications effective? This is something that DOL is regularly checking on when there's an audit. Okay, so DOL first engaged on this issue in a formal way, not terribly long ago. In 2014, they issued what's called a Field Assistance Bulletin on missing participants, not as robust in any sense as what they released 2 years ago, but just a representative statement from that 2014 guidance. The department said, consistent with their obligations of prudence and loyalty, plan fiduciaries must make reasonable efforts to locate missing participants or beneficiaries. So they were explicitly out there as a regulator that this needed to be a priority for plan fiduciaries as of 2014. Here's some more about that 2014 guidance. They included a list of required steps that should be taken by plans to locate MPs. MPs is my abbreviation for missing participants. Now, here's what the 2014 guidance said was the preferred option if you could not find somebody. The preferred option under this 2014 guidance was to do a direct rollover to an IRA for the participant. The main advantage of this, is probably you all know, is that there's no taxation for these direct rollovers. Now, if there's some reason that an IRA could not be established for the participant, there were two other alternatives that the 2014 guidance gave. One, opening an interest-bearing savings account for the participant, or two, transferring the money to a state unclaimed property fund. The huge downside for both of these two latter approaches, of course, is that they result in taxable distributions. So the DOL made clear they should only be used as a last resort if you can't, for some reason, establish an IRA. Okay, so quickly, and now we're talking about the 2021 guidance. Quickly, I want to talk about one of those documents, which was an update to the 2014 guidance, and in particular talked about another option that wasn't available in 2014 that plans can use in the event they're not able to locate a participant. So in 2017, the Pension Benefit Guaranty Corporation, another federal agency in this benefit space, created what's called the Defined Contribution Missing Participants Program. So it's been around for about 6 years now. This is an option for plans to put retirement benefits for lost participants if they can't find them. And so this 2021 guidance document said that although it's not yet part of their explicit missing participants program, they would, what's the term? They would not enforce any penalties against plans if a plan does their diligent search for a missing participant, is unable to find them, and transfers the money into this PBDC missing participants program. Now, the department noted several advantages for this program, and I do think this is why they're pushing it. It's a centralized program that applies nationwide. So if you are a missing participant and you're trying to find your money, you're like, I think I have a 401k from 1995 when I worked for company X. This would be a one-stop place where they could go and try to find that benefit. The PBDC also on their end will do active searches on a regular basis for participants that have been listed in this program. And then if they're able to find the missing participant, the PBDC does offer lifetime income options if the balances are over $5,000. So these are all good things, reasons why the department is trying to encourage transfers into this PBDC program. Okay, now I'm going to talk about the most useful document from the 2021 guidance, and that was their best practices document. And just to be clear, this does apply both to your 401k type plans as well as the traditional defined benefit pension plans. Okay, the first thing that the DOL said in the document was talk about when should you be on alert that there is a problem. When do you have your Houston, we have a problem moment? And they called this fiduciary red flags. So here's red flags that the department put forward in this document. Do you have more than a small number of missing participants? Do you have more than a small number of participants who've reached normal retirement age but have not started their benefits? Is there missing or incomplete contact info or census data for the plan? Do you not have any policies or procedures for dealing with undeliverable mail or email to participants? Do you have a lack of policies or procedures for handling uncashed benefit checks? If you ask yourself these questions and the answer is yes, you should be starting to do some more due diligence, sharpening your policies or procedures, upping your execution. But this is what to be on alert for. And if you're asking what is a small number, the department did not define what they mean by a small number. The department did add the caveat, which is always true in the law on ERISA fiduciaries, that they can't make bright line tests in this category. It's going to be, if there is an audit situation and they're looking at assessing a fiduciary violation, it's going to be a facts and circumstances analysis. What might be required as a fiduciary in one plan may not be required in another plan. But this is the duty of a fiduciary. You use your powers as a rational individual, and you do what you think needs to be done to protect the retirement benefits for the people in your plan and their beneficiaries. Okay, so now I'm going to go through the DOL's recommendations in 4 different categories that they listed of best practices. The first category is record keeping, maintaining accurate information on plan participants. So this is what the department recommended in terms of record keeping. Periodically contacting participants to make sure their information stays current. Reminding them to advise the plan anytime there's a change in their information. When you communicate with them, including contact information change requests. Again, just another way to remind them to try to keep contact information current. Here's one I've been seeing more frequently: having an online process to make it easier for participants to update contact information, and in some cases requiring them to confirm or update their contact information when they log into their online benefit account. Always making sure that if there's undeliverable mail, undeliverable email, cash checks that are going uncashed, that there's some kind of follow-up. And then, as I mentioned on the front end today, if there's a merger situation, when records are being transferred from one entity to another through some kind of acquisition, just be exceedingly careful that all the information is getting transferred. You're not losing any information. And in terms of communications, which we'll talk about on the next slide, it's very helpful to remind people who were not ever employed by the buyer of an acquisition that this refers to their benefit earned under X employer, because a lot of people may not even know that their employer was purchased, 5 years after they left employment, which can make communications especially challenging. Okay, so communication best practices. Always use plain English. Do not use benefits jargon. I've tried to keep benefits jargon out of this presentation as much as I can, but as you guys know who work in this space, there's all kinds of jargon. As much as you can, scrub anything out of your communications. Use regular language as much as you can. State upfront what the communication is about, especially if it's about a participant's eligibility to receive benefits. I do want to add a caveat here, and this may be something some of you are thinking about. The other side of this is the risk of fraud. Unfortunately, there's kind of a proportion between how obvious you make a communication that we're talking about the ability to receive substantial sums of money and the risk that a fraudster could try to, if he or she got his hands on that communication, could try to, do mischief. So that is something that as a fiduciary, you need to weigh and balance the risks, but at least be on guard or be aware that the more you can make it clear to somebody that this communication requires you to take action to start receiving money, the more likely you'll get that envelope opened, that email opened. Anyway, so that's one of the best practices. As I said before, if you're in a situation where the company under which the benefit was earned is no longer the company that runs the plan, use the name of that original company in all the communications to just really increase the odds that somebody realizes, yes, this is not spam. I'm talking about your 401k when you worked for Acme Corp. Always encourage your participants to use the plan websites and toll-free numbers just as much as you can do to get participants aware of how they can find information. Another thing that DOL recommended is explaining that the plan can help consolidate benefits from prior employers or other IRAs. This is just another kind of incentive that can be a hook to make sure participants take the time to engage with the communication and hopefully get connected to their benefits. Okay, number three, or the third category of the department's best practices is how to search. When you can't find the participant, how do you try to locate them? And a lot of this is just variations on common sense, but I think it's still helpful. See what kind of records or what kind of information is in your plan records, what kind of information is in the employer's records in terms of contact info. Check with the other designated beneficiaries to the extent you have contact info for them. Hey, do you know how we can reach your dad? How do we reach your mom? Whoever could be a beneficiary that the participant designated. Online search engines, public databases, social media. There could be privacy concerns here, but know that this is an acceptable option. You're not going to be transgressing just because you decided to search for somebody on Facebook or LinkedIn or Instagram, what have you. There's commercial locator services. Credit reporting agencies have unbelievable amounts of information using certified mail. If your searches are continuing to yield no fruit, see if there's a death record of the individual. Former colleagues, a lot of people don't think about this, but if people are still at the company that used to work with this individual, it's totally above board and even recommended to see if they know anything about his or her whereabouts, how to contact them. The DOL made a point to say, keep doing these things. It's not like you try once and fail, like keep trying. Interestingly, they did not give in their 2021 guidance specific guidelines on dealing with non-responsive participants or uncashed benefit checks. Okay, the final category of the DOL's best practice document is just about having written policies and using documents to record what actions have been taken. And this is especially helpful in the event that there is an audit. So make sure that you have procedures and policies that cover the issue of missing participants and make sure that they're followed. When you're trying to find participants, document the steps taken. When you're making changes to templates for communications, document what you're doing and why you're doing it. This last bullet is important because there's a lot of third-party record keepers. Just be wary of being hands-off with the record keeper. If you see that the record keeper's communications, for instance, are not labeling benefits earned under prior employers that have been acquired, like make sure they change that process. Make sure that they're themselves following what the DOL has recommended as a best practice. Okay, I believe we wanted to discuss just what it will look like, or at least likely look like, if there is a DOL audit on this topic of missing participants. And that was one of the final of the three documents DOL gave was specifically about audits. So they're going to want to request, or they will request, the plan documents, and particularly the summary plan description, because the department is going to want to verify the plan's distribution rules, which would be in those documents. They're going to want to look at the census records for the plan. If it's a defined benefit plan, they're going to ask for the actuarial reports, because that will help them see where the plan's demographics lie. They're going to want to know how the plan currently communicates with terminated vested participants, those who would be benefit eligible. And they're going to want to know what are the steps the plan is currently using when they have missing participants to try to find them. What are they looking for? Any kind of systemic error in record keeping. Is there data that's not getting transferred between the plan and a third-party record keeper? Was there, or is there a problem when an acquisition happens in the transfer of records to the acquiring company? In terms of missing participants, is the plan actively looking when there is a missing participant that's verified? Are they making sure they're even paying attention to when there's unresponsive participants, when checks are going uncashed? What are they doing to find the missing participant? They look for the plan's communications procedures. In particular, are they giving adequate notice to participants who are on the verge of becoming eligible to begin receiving benefits? Does the plan have inadequate procedures to make sure that the required minimum distributions under the IRS rules are beginning when they're supposed to begin? And is there procedures regarding when benefit checks are going uncashed? How do you come out on the back end of these audits? What is the DOL going to need to see to close one of these audits? They're going to make sure that you've done what you can to locate all missing participants that have been identified to the extent possible. If there was any problems or deficiencies found in policies and procedures, you're going to want to make sure that those have been fixed, that those have been supplemented, revised, what have you. They will not likely cite individual fiduciaries for violations unless there's substantial or widespread problems, which in my experience tends not to be the case. And if all these corrective steps have been taken, they will cite those steps when they close the case. I briefly wanted to mention, we're closing up here. I wanted to mention an issue with the IRS required minimum distribution rules, which is kind of lurking in the background here. Obviously, if you have a missing participant, you're not going to be able to make the required minimum distribution at the time it's to be required. And we talked about earlier how there's other ways you can transfer those funds to an IRA, or now the PBDC has their missing participants program. And this is just a violation. There's penalties for it. There's excise taxes equal to 50% of the required minimum distribution. But know that in the world of missing participants, the IRS understands this. There's a memorandum published in fall of 2019 that says this will not cause a violation if the plan has taken steps to locate the MP. And they also said, if you use the procedures of the DOL, that you would have been found to satisfy those required steps to locate the missing participant. So basically, now that we have that 2021 guidance, in particular the best practices document, if you're doing those things or doing similar things, you should be in the clear, even though there technically will be a violation, because the IRS has said, if you're doing what you need to try to find missing participants, we will not cite you for a required minimum distribution violation. Okay, briefly, this is still a live issue. There's still a fair amount of attention being paid to missing participants, both in Congress and in the executive branch. So President Biden's most recent budget, his 2024 budget, would authorize $5 million and 22 full-time employees for the Department of Labor to have a permanent, dedicated program whose sole goal is to reunite missing participants with their retirement benefits. That hasn't been acted upon yet, so we don't know if Congress will agree, but that is what the Biden administration requested. Congress passed at the end of 2022 the Secure Act 2.0, and that contained many retirement benefit provisions. One of them was a requirement that the Department of Labor and the Department of Treasury create a new online searchable lost and found database of retirement plans, which, as you would imagine, would be helpful for anybody who's trying to find retirement benefits that they believe they've earned. That database is required to be online under the Secure Act 2.0 by the end of 2024, so not quite a year and a half from now. And soon after that, to populate that database, plans are going to be required to give the department information about all participants that have outstanding account balances. And my understanding, I don't know if there's been regs yet on how this will work, but my understanding is that will be done via a new schedule to the Form 5500 that plans have to file every year. So that's something to be on the lookout for. Another advantage of this online database, once it gets up and running, is for plans, if you're looking for a missing participant, again, this database doesn't exist yet, but it seems like it'd be something where you could search the database as a plan and see if this participant is listed anywhere else, and therefore perhaps be able to find updated contact information so that you could connect him to his benefits with your company. So could have benefits for both participants as well as fiduciaries. Okay. What should you take away from today? What should you be doing if you're not already doing it? I hope you take away that this is a big deal. As I said at the beginning, this kind of gets to the core of why we have the federal retirement law. We want to make sure the people who've earned benefits get those benefits. It's also a big deal to the Department of Labor. They may have, as I said in the last slide, they may have, beginning soon, a designated kind of missing participant office to try to make sure people are getting connected to their savings. But we're dealing with potential breaches of fiduciary duties under ERISA. If you're audited, it's going to be something that the department looks at. And you also have the IRS RMD rules that, again, if you do your diligence in terms of trying to locate, you're in the clear. If you don't do your due diligence, you will be found to violate it. And again, that's a 50% excise tax penalty on the amount of the distribution. So, do you have currently policies and procedures on missing participants, policies and procedures that would help you avoid participants going missing in the first place, and policies and procedures to try to locate them if they do go missing? If you have those policies and procedures, are you executing them? And I'll leave you with this parting thought, in case this is helpful. I think it's helpful. Think about the missing participant golden rule. Doing the right thing in this space is basically mean treat these people who are missing as if they're your parents. Obviously, the idea that your parents have retirement savings that are just floating in the ether while they are trying to squeak by on their Social Security, that's not a happy thought. Treat the people in your plan that are missing like they were your parents. That's my MP golden rule. So with that, I hope this was helpful. It's kind of a good topic, I think, because it is so concrete, so core to what we're trying to do as plan fiduciaries. If you have any questions, my contact information is on this next slide. I also have several colleagues here that are very happy to help. So please don't hesitate to reach out if you have any questions about your plan's efforts to reunite missing participants with their retirement. Thank you very much.